Now, former President Jacob Zuma's private prosecution case against President Cyril Ramaphosa has been postponed to the 26th of May in the High Court in Johannesburg. Law professor Peirre De Vos says the attempt by Zuma to privately prosecute Cyril Ramaphosa for failing to intervene in an internal National Prosecuting Authority matter raises broader questions about the potential abuse of private prosecutions by politically powerful or wealthy individuals. For more, we're joined by the law professor, Mr. De Vos himself. He's from the University of Cape Town. Mr. De Vos, thank you very much for your time. This reminds me of a particular case when the SCA, the Supreme Court of Appeal, had to hear the case of the spy tapes. And I think the quote, if I remember correctly, I actually have it here from T.S. Eliot. He said it is the current end of the unending. But how does the court balance it? Because at the end of the day, if someone applies for the court to hear them out, by law, the court has to do it.
In terms of criminal prosecution, of course, the South African Constitution makes clear that it should really be the prosecuting authority who is supposed to be independent, impartial. They have to decide whether to prosecute or not to prosecute, primarily based on whether there's enough evidence. In private prosecutions, of course, what can happen, not only in the case of Mr. Zuma prosecuting Mr. Ramaphosa, but in many other cases, is that somebody might have a vendetta or whatever against somebody, and then they can prosecute. And in terms of the law at the moment, this could happen without there being any assessment of whether there is a criminal offense actually committed, or if the facts were proven, it would amount to a criminal offense, or that there are at least some evidence to back this up. So in the wrong hands, it could be used by people, for example, to silence their critics. A big company might get somebody who's been personally harmed, and they would then get that person to privately prosecute somebody who's been criticizing the company or whatever the case might be. So that is really the concern that I expressed.
Yeah. And I mean, Mr. De Vos, maybe the law, the Act, the Criminal Procedure Act, which obviously then stipulates what happens in the case when a person applies to privately prosecute someone, that nulla prosequi certificate that the NPA would ordinarily sign off on when it says we cannot prosecute this particular case, we don't see prospects of success, etc. Maybe the Act should stipulate, or change legislature maybe to say exactly what that letter is supposed to say. Because, for instance, with this particular letter, the issue is that it doesn't necessarily say that Mr. Zuma wanted to prosecute these two people and we can't help him with these two people. It's just open-ended.
Yes, so we will see maybe in the court proceedings that is now going to follow the case of Mr. Zuma prosecuting Mr. Ramaphosa, the courts might give some clarity on this. So yes, in one way, it would be helpful for us to know whether the prosecuting authority has to issue such a certificate, even when the complaint has nothing to do with the criminal law. Another option is perhaps for the court to first check and say, yes, we're not assessing whether you're going to win the case, but at least there is some reasonable evidence here that might justify prosecution. In that case, it will limit perhaps the potential abuse that might occur in these cases.
And Mr. De Vos, this also, I assume, would then put the entire judicial system in danger of being a part of political ploys, or, as you said earlier, people who just have a vendetta against somebody, and the things just keep rolling and the courts are just embroiled in all of this, right?
Well, of course, if people go to the courts, and in our Constitution, you have a right of access to court for any try and resolve disputes, but also there is, there is a provision for prosecution. As long as the courts, of course, stick to the law, they are going to have to make the decision, and as long as they don't get personally embroiled or pick sides, regardless of the facts for the law in any of these cases. And so far, mostly, I think our courts have not been too bad at it. Of course, except the side who loses will always claim that the court is somehow biased against them or politically.
Yeah, very important for that separation of powers, Mr. De Vos. Now, pertaining to this particular case, for example, the Zuma versus Ramaphosa case, there was a mention by Zuma's lawyer, Advocate Dalimpofu, in court yesterday, saying that the former president intends on appealing the interim interdict, urgent interdict that was granted to his to Ramaphosa on Monday. I'm not understanding. Is it possible to appeal an interim interdict?
It's complicated in law. It's not easy to do so. And in this case, it also seems superfluous and really a waste of time, because this is just an interdict that is in place until the court in May is going to hear the substance of the argument of Mr. Ramaphosa, and they're going to decide whether this was an unlawful prosecution or not. So that in any case means that the case will be resolved in the next few months, this way or that way. So, yeah, I'm not sure why Mr. Zuma and his lawyers are taking that route.
And I think for me, what it does also, Mr. De Vos, is that it basically brings up what I said to you earlier in terms of the debate around the Criminal Procedure Act, because even though prosecutors are told that they need to act in good faith, etc., in the Criminal Procedure Act, for instance, it does not require that a private prosecutor should have prima facie evidence against the person that they're going to prosecute, whereas if it is given to the NPA, they should have prima facie evidence. So then the court is forced to just hear the case anyway. So shouldn't the act also just be looked at? Shouldn't there be legislature debate around the act itself and strengthening it?
I do believe so, and as I've suggested earlier, it might be to involve the courts in some way, at least to give that there should be minimum requirements for a private prosecution to go ahead. Of course, the counter-argument is that if there is no case, the court is going to acquit the person that is being prosecuted. You can also, as President Ramaphosa did, you can go to the court and get an interdict. But that is, of course, something that is open to somebody like President Ramaphosa, because he is paying for this from state. Well, he's actually paying for this through state funds. We are paying for this. But if you are, you and me, and you are privately prosecuted, then it's going to be much more difficult, because it can really cost hundreds of thousands or even millions if the case drags on, and if the other side has a lot of money and lawyers to pay.
Yeah, that's exactly where I was going to go with this, that the two people that we're currently talking about have access, whether it's through the state or their friends, etc. They are politically powerful. You know, they do have connections, etc. So they can go ahead and let it play out in the courts for however many months that they want to, really, even after May. But somebody like you and I, you know, how do we then get the courts to understand that this also goes against the constitutional right of the other? You know, that's why I was saying, you know, it's the balancing of it all that is difficult as well.
Yes. I think the courts are in a difficult position because the legislation actually does not provide for the protections that I think will help to prevent this. So maybe there needs to be an amendment of the legislation. But the courts have, in part, in the article I wrote, I mentioned the Nundalal case, in which the court was very critical of the private prosecutor, who was basically doing it to pursue a vendetta against the other person who had no money. He had money, and he used this money and the system to try and punish the other person who had won in another court case against him. So I think legislative amendment is probably the best way to balance this interest, to allow for private prosecution on the one hand, but also to make sure that it is only going to go ahead at least if there is some reason for the prosecution or some justification for the prosecution.
So President Ramaphosa won round one, right? Part A, the ruling was in his favor. You know, in your expert analysis, Part B, he wants the summonses that were handed by Jacob Zuma and his team to be deemed unlawful and unconstitutional, etc. Looking at what the court said on Monday, does it look positive for the court to rule in the former president's favor in Part B, or are we just looking too much into it because the court just had to deal with how urgent it was that the matter not be heard yesterday.
Yes, one cannot really assess from the judgment that was handed down on the interim what would happen later, and the court is also careful to say we are not expressing a view on this. I personally would be quite surprised, even shocked, if the court in that other application rules in favor of former President Zuma, because the prosecution is really based on the failure of the president, as you said in the beginning, to interfere with the National Prosecuting Authority and appointing a commission to investigate Belit Downer and what he did. That is unlawful. That is a criminal offense in terms of the National Prosecuting Authority Act. So the court must say that this is a vexatious prosecution, that there is not a crime. In fact, what they want the president to have done would have constituted a criminal offense. So it's a little bit bizarre.
I mean, to a lot of South Africans, Mr. De Vos, and some experts, this looks like a political ploy more than anything that has to do with law. And I'm not asking you to comment necessarily about Zuma versus Ramaphosa politically and their home, the ANC, etc. But I want to ask you specifically about the fact that we have to carry the invoice. The taxpayer has to be the one that pays for this. And I know previously there has been a court order that compelled the former president to pay back the money in some of his legal turfs. But if this continues, we need to continue paying for it. Shouldn't that law also be changed? Because, I mean, we're already a country that is suffering. Why should we carry the bill for such things where South Africans are looking at it and they are saying this doesn't even make any sense?
Yes, so the cost comes in two ways. The one is the cost for the legal representatives. Mr. Zuma, I presume, is now paying, or his benefactors are paying for his own lawyers, so the public is not paying for that. They used to. The president, of course, because he's being before the court in his capacity as president, we are paying for that. But there's another thing, and that is that the court system is being taxed by this. And that is the cost that we don't see. To pay for the upkeep of the building, for the judges, for all of those things. If everybody does private prosecutions, that will overburden or further overburden the system that is already burdened, and that has a cost implication as well.